In the eyes of the law, what really separates a tragic mistake from an act of murder? It can be a razor-thin line. Today, we're going to walk that line and break down the incredibly complex charge of second-degree murder right here in Arizona. We'll demystify what it is, how prosecutors can charge it, and what the, frankly, severe consequences are. Let's dive in.
Okay, so right off the bat, let's get the single biggest difference out of the way. When you hear first-degree murder, I want you to think one thing: planning, premeditation, a scheme. Second-degree murder, on the other hand, that's about an act that happens without a pre-existing plan. And that single distinction, planned versus unplanned, is the crucial legal line we're going to be exploring today.
And you know the drill. Here's our super important disclaimer. This is all for educational purposes. We're breaking down the law to understand it, but this is absolutely not a substitute for real legal advice from a qualified attorney.
So if it isn't planned, what actually makes it murder? Well, the answer to that really starts with the official legal definition itself.
Now, on the surface, the definition seems pretty simple, right? Causing a death without premeditation. But trust me, the complexity here is huge. This means prosecutors don't need to find a detailed plot. They just have to prove what was going through a person's mind at the very moment the act occurred.
And you might think, okay, unplanned killing, I get it. But it's not that simple. The law actually gives prosecutors 3 completely different ways to secure a second-degree murder conviction. And it all comes down to 3 distinct mental states: intent, knowledge, and what's called extreme indifference.
The first path is the one that's probably most intuitive. It's intentional. So, picture a sudden argument that just explodes into violence. There was no plan to kill someone an hour ago or even 5 minutes ago. But in that flash of rage, the decision was made. The intent to kill was formed right there, in the moment.
Path number 2 is knowing. Now, this is different. In this case, the person might not have actually wanted anyone to die, but they knew their actions were so dangerous that they could easily be fatal. So the legal focus here isn't on the desire to kill, but on the simple awareness that their actions were deadly. And finally, we get to the third and honestly, maybe the most chilling path: extreme indifference. Now, this is not just being careless. This isn't a simple mistake. We're talking about a level of recklessness so profound, so off the charts, that it shows a complete and utter disregard for human life itself. It's like your actions are telling the world you just don't care if someone lives or dies.
So what does that actually look like in the real world? Well, this example is chillingly clear: recklessly firing a gun into a crowd. The shooter might not be aiming at any one person, but the act itself, that action, shows such an extreme indifference to human life that if someone dies as a result, that can be charged as second-degree murder.
So, okay, those are the 3 ways someone can face the charge. But what happens after a conviction? Now we've got to look at the price, which is the sentencing and the life-altering consequences that follow. Before we get into all the details, I just want this number to sink in for a second. 25 years. That's the maximum presumptive sentence for a standard second-degree murder conviction. And as you're about to see, the term calendar years is one of the most important parts of this whole thing.
This table here really shows how dramatically that sentence can shift based on the specifics. So for a standard conviction, the presumptive or typical sentence is 16 years. But look at this. If the victim was under 15, that jumps to a presumptive 30 years. If it's a repeat offender, 20, and in both of those cases, the maximum sentence is no longer 25 years, it's life in prison.
And when the law says calendar year, they are not messing around. This isn't your typical sentence where you can get time off for good behavior. It means every single day of that sentence, 365 days a year, must be served behind bars. No parole, no probation, no chance of getting out early.
This all leads to another question that I get all the time. If a death is caused by someone being reckless, why is it sometimes second-degree murder, but other times it's the lesser charge of manslaughter? It's a really fine but critical legal line.
So the difference really comes down to the degree of recklessness. Manslaughter is what gets charged for reckless behavior that results in a death. But for that charge to become second-degree murder, the recklessness has to climb to that much higher standard we just talked about: a complete and extreme indifference to human life. It's a whole different level of disregard.
Okay, let's switch gears and move into a quick rapid-fire section to tackle some of the most common questions and just make sure these ideas are crystal clear.
First up, and this is a big one, Can you really truly be charged with murder if you never actually intended for anyone to die?
And the answer to that is an absolute, unequivocal yes. As we've just seen, intent is only one of the three paths. If you acted with the knowledge that what you were doing could be fatal, or with that extreme indifference to human life, that is enough to support a second-degree murder charge.
All right, next question. What about being intoxicated? If someone was under the influence of drugs or alcohol when the event happened, can that be used as a defense?
The law on this one is incredibly clear. The answer is almost never. Voluntary intoxication, and that just means you chose to drink the alcohol or take the drugs, is not a valid defense. The law is designed to hold people responsible for their actions even when they're under the influence. So let's recap the three most important things to take away from all this. First, at its core, second-degree murder is an unplanned killing. Second, the charge all hinges on one of those three mental states: intentional, knowing, or extreme indifference. And third, the consequences are incredibly severe. It's a Class 1 felony, and you're looking at 10 to 25 calendar years in prison, and sometimes even more.
And all of that leaves us with one final big question that really sits at the heart of this entire law. At what precise moment does reckless behavior become so severe, so indifferent, that it crosses that legal line from a lesser charge into murder? That's a question that juries and courts have to grapple with every single day, and it just shows you the profound complexities of justice. Thanks for joining this breakdown.